Well, hello, everyone. We're going to spend a few minutes today talking about the debt collection process. Let me zoom in and make it a little bit larger, and we'll scroll the page down as we go. We wanted to give a standardized explanation of what typically happens when a client doesn't pay as agreed. It's important to understand that we have three primary goals with our Access to Capital program. It's to, number one, help clients improve financial literacy. We do that through a 4-module process using award-winning curriculum developed by the FDIC, promoted by the SBA. It is A+. Secondly, we help clients build a loan package. And this is important because the business plan, the financial forecast, and so forth, those are very important elements to give a lender and or a banker an understanding of the request for funds, the use of funds, and to try to justify an approval for that loan. And then ultimately what we do with our Access to Capital is help clients access capital. And so that is to help them get at least $100,000 to start or grow a business. Now, within that, we have written agreements. And as you may know, agreements don't have to be written. Agreements can be oral or written. All of our agreements are written. And that's true with our clients and distribution partners, because we want to have clarity of what each party has promised to do and the responsibilities if that doesn't happen. So if, getting down to debt collection, if we have a client that doesn't do what they promised to do, in other words, they've breached the agreement, we want to try to resolve it, obviously, directly, and we'll do everything that we can. But in some cases, clients don't do what they promised to do. For instance, maybe they don't accept funding to be able to cover their refundable deposit. We invoice them and then they don't pay, so they're in default. Or they get a cash capital raise and they don't pay the performance fee. There's different reasons or situations, but what we do is we, in all cases, follow a professional and legally compliant process. Here is the process, the typical process. So typically we will start with issuing an invoice and or a demand letter. We sent a demand letter out to a client yesterday. I guess I could have shown it to you. But the bottom line is, we're giving notice to the client that we believe that they have breached their agreement. Of course, it needs to state why and how to resolve it. I do put in parentheses here because in some cases we just sell off the debt. We have law firms and others that buy debt from us, so we sell it off and then they go collect it. So if that's the case, that's their process, and I couldn't even begin to tell you what their process is. I don't know, but I'm telling you what our internal process is if the debt is not sold or auctioned off. And as I mentioned, we have 3 law firms on retainer, but one of which is specifically a litigation firm that helps us with these matters. Okay, so the point is, if we've got a problem, we can't resolve it, we communicate in writing to the client via invoice and or a demand letter. So what we want to do is resolve the issue, get the client back in compliance and proceed forward. But if the client doesn't offer to resolve, which could be as easy as just setting up a payment arrangement, then we'll typically go forward to litigation. So that's different. When the debt is sold off, we typically see the law firms that buy debt, they typically will go through a collections process, reporting to the bureaus, more of a traditional debt collection process. Our internal model is not that at all. It is to go to litigation if we cannot resolve it directly with the client. Now, there's 2 scenarios that can happen, and we'll go through each. There could be a civil issue and or a criminal issue with the client. We're going to start with the civil. So if we have a civil issue, then a lawsuit will be filed. So again, effort will be made to resolve with the client, but if we can't get them to comply, we can't get a payment arrangement set up, we can't get them to work with us, then there's no other option but to litigate. The lawsuits are always filed in Wood County, Texas, and that's required in the agreement. We don't have any flexibility. Some clients say, oh, no, I live in Miami, Florida. You can't file in Wood County, Texas. Well, the jurisdiction is clearly stated in the agreement, so we're required to do that. And of course, they're required to accept that because it's part of the agreement. Then the client's going to be served, and they could be served either by a process server, but typically they are served by a sheriff. So the local sheriff will come out, and they may go to the individual's work, they may go to their home. We see sometimes the sheriffs will go out at 3 in the morning because it's most likely that they're home, and that's a little bit alarming. So I wish that weren't the case, but you get sheriff or sheriffs knocking on your door at 3 in the morning to serve you. That's not a good start, but that is part of the process. Is if we're going to do litigation, then the plaintiff, I'm sorry, the defendant has to be served. So what we do is, which is a little bit different than others, we immediately go into discovery. And so discovery is important because we often, well, I shouldn't say we often, we find that some of our clients that have signed up that are not participating, they got funding, but they didn't disclose that. So what we do is we are going to, through the court proceedings, collect financial information about the client, especially personal and business bank statements, because we need to see what type of funds that they've received since they've been in the program, because there's been multiple instances where they received funding, they didn't disclose it to us, and then they've gone radio silent. And so they're required to adhere to those discovery requests. And if not, it's considered contempt of the court, and then they could be arrested for that. So then what will happen is a case, usually it'll be a pretrial hearing, but let's just skip that and just assume that we go straight to the day in court. The court is in Wood County, Texas. Again, we don't have any flexibility on that. That's what's written into the agreement. So we have uniform jurisdiction. And to the best of my knowledge, there's no more Zoom type proceedings. People have to show up in person. The client will then be responsible for the amounts owed under the agreement, which is what we tried to resolve even before this process started. But I think sometimes clients don't realize that they still owe what they owe, plus they're going to have responsibility for the legal costs, the court fees, the late fees. And so it's always better for the client to try to resolve this without us using the court's time and going through this process, because the bill just becomes larger. And then, so once we win the case, which we almost always do because it's a clear-cut contractual dispute, then if the client doesn't voluntarily pay, then that's where, again, the attorneys get involved and they do bank garnishments. They do do wage garnishments. They can do seizure of personal and or business assets. They often call that the sheriff's sale, where they'll go out and just do an auction. So they auction off the person's toaster to go towards this funds. They auction off the computer equipment of the business and so forth. And then liens can be filed. So this is a description of the typical process to resolve in a civil matter when a client doesn't pay. Now, again, I'm not an attorney, so I'm not giving legal advice, but under certain circumstances, it could be pursued as theft or conversion, or those other terms that attorneys could describe to you that I really am not qualified to do so. But it's possible that it could be pursued as a criminal case against the defendant as well as civil. So if that's the case, all those things we talked about above would be the case civilly. But then when the sheriff comes out, instead of just serving them, the sheriff will usually come in a group or a posse, if you will, and actually arrest the client. Now, since the proceedings are typically to be held in Wood County, Texas, what will happen is the client will be arrested and taken to the local jail, and the term is held. They may not even be booked in the local jail. My daughter was the nurse, the clinic director of the Wood County Jail. So I have a pretty good understanding from her dinner time stories of how it works. And, it's never a great deal to be booked in a jail. According to her, they do everything from the strip search and the body cavity check. And it's not good from what she shared with me. But the bottom line is the client will end up in Wood County for legal proceedings if it falls under criminal. So I'm not saying all do. It just depends upon how the prosecutor sees the defendant's action. So with all that being said, get here to the bottom, our goal is to obviously avoid using the court's time. We want to resolve the contractual issues directly. But we are dependent upon the client's willingness to communicate, and they can call us at 903-200-8781 to resolve. Because our goal is not to litigate. Our goal is to help build financial literacy, help clients build a loan package, and help them access capital. But they have to understand that written agreements are enforceable. And so we need to do our part, and we would ask them to do their part. So again, if you have any other questions about that, give us a call. Stand by, please.